Hi, I'm David Marchant, the founder of OffshoreAlert, which investigates participants in high-value cross-border finance with an emphasis on high-confidentiality jurisdictions. Our specialty is exposing investment fraud while it's in progress. Enjoy our content.
Hi, everyone. This is Ed Davis from Sequor Law in Miami, and I am chairing this first half of a two-part panel that we have done historically at OffshoreAlert. First time we're doing it virtually, and the panel is called High Value Cross-Border Recovery, Tips from the Experts. And the intent of this is to be a master's class with regard to asset recovery and cross-border insolvency issues, both from a legal perspective, an investigative perspective, and a forensics perspective. We're not trying to do a basic panel here, and the first half will be from 11 till noon Eastern time, and then from 1 till 2 Eastern time. So there'll be a separate set of speakers. I'll be moderating both panels. And our intent is to pick out certain leading issues that have come up over the past year and flag those for the practitioners that are out there, and also lead you to new techniques and tips. And over the years, many techniques and tips have been developed through the use of this panel and then deployed in the field by practitioners such as those you see on the phone. I am not going to take valuable time away from these speakers to introduce them in any great detail, because all of the information is on your laptop. So you can go and read their amazing bios at your leisure, and they are amazing bios and you should read them. I can tell you, though, I've had the pleasure and privilege to work with almost all of them. So Martin Kenney from Martin Kenney & Co. in the BVI is a brother to me and over the years, and has worked with me on many cases. Welcome, Martin. Warren Gluck, another brother from a different mother at Holland and Knight in New York, and we've worked on cases together, and even been adverse firm to firm over the years. Jonathan Tickner, another very close friend whose firm and my firm have worked together on several matters at Peters in London, and really just a wonderful associate with my partner, Arnie Lacayo as well, and a leader in Asia. And then lastly, Snežana Gebauer from K2 Integrity, who I've not had the pleasure of working with in the past, but I hope to in the future. And this is my first chance to really meet her and work with her. So I'm looking forward to the opportunity. So we're not going to do more introductions than that. We thought we might just do a quick lightning round with everyone with regard to one aspect of your practice, 30 seconds to a minute, that has developed in a good or bad way, positive or negative way, with regard to COVID. So I'm just going to follow the batting order that's set forth in the program. And Martin, tell us something that you've encountered, good or bad, that has come out of the whole COVID situation that we've all been dealing with over the past 9 months, 10 months.
Well, I say the worst thing is we're being deprived of our personal relationships and friendships, Ed, that we're not able to twice a year meet as Fraudnet members somewhere in the world, that we are having to do things remotely. That's the worst bit, lack of human contact that we're used to. But as to work, our practice has never been as busy as we are now. We've seen an explosion of work, and I don't know, I guess it's just speculative as to whether it's linked to the, quote, some of the economic fallout from the COVID pandemic or not. All I say is we're extremely busy, and the courts are functioning, even though we're doing trials and hearings by Zoom here in the BVI and elsewhere. Like in Toronto, we're about to start a trial in January for 3 months, suing a bank in the Stanford case that you've been working on with me, Ed, for almost 10 years for $4 billion of damages. And the entire trial will be done for 3 months in Zoom, which is interesting. That means that witnesses from around the world can participate in a trial more efficiently than before. So I'd say it's been a difficult situation for everybody personally, but I think certainly in the asset recovery space, we're all most of us are really busy, and there are ways in which we can help folks recover assets, notwithstanding the other difficulties we're facing.
Super. Let's hear from Warren on the same point, because we're going to make this a true lightning round and see if you could tell us something that good and bad, or good or bad, that you've experienced as a result of COVID?
Sure. I think the bad obviously speaks for itself. On the positive side, from my perspective, the best thing that's come out of this is the transition to video depositions. These are working well. I've done a lot in the last 9 months. It's not just cheaper for the client, which it is. They work well. They work as well as this session. And having seen it now in practice, I don't think I'm going to go back. I think we're going to seek video depositions where available in almost every case moving forward. And frankly, I don't think we would have thought that it would be practical before this. A lot of the ways people weren't sure that law firms and entire investigation and accounting firms could really make the transition to working from home. But the video deposition, I have found, I've probably done 20 so far, it's just since COVID, and they all worked well. It's not that we have not had one problem that wouldn't have happened in a live deposition. So I think that's here to stay, and I think that's a plus now.
Super. So following down the line, Jonathan, same question to you.
Thank you, Ed. I mean, I just following on really from what Martin and Warren have said, I think the good point is, so far as the English courts are concerned, it's business as usual. The courts stayed at the High Court, the commercial courts stayed open immediately following lockdown on the third week of March. And on the same day, the Lord Chief Justice made announcements that civil justice would continue unimpeded. And it really is because of technology that there hasn't been any hiccups. I mean, the sense that trials have continued, hearings have continued, interlocutory hearings. The judges have been very good at picking this up and running with it without any real complaint. And so hearings have carried on. They've all been done virtually. And I think that that's sort of been the miracle of technology, in the sense that I don't think, as a lawyer, I would have anticipated that if you'd asked me this question in February last year, will we be in a world of virtual technology for all hearings? So I think that's an incredibly positive point. What I think is interesting is going to be how virtual kind of witness testimony is treated, and really trials. I mean, there have been trials in the High Court, and I'd be interested to see what other people say. And so far, certainly testimony has been given virtually. But I think, as asset recovery lawyers, and there's lawyers who, want to see really the witnesses in the room, so, to get eye contact, to get demeanor. That isn't possible, obviously, if they're giving virtual witness testimony. And certainly there has been criticism that cross-examination hasn't been satisfactory when done virtually. And obviously, virtual testimony has happened pre-COVID. So I think that is interesting, and whether or not a witness can have notes, the extent to which you can police how the witness is giving evidence, all of that I think are real question marks, kind of moving forward.
I think that's right. Thank you. So now, having heard from three lawyers in a row, let's hear from Snežana with regards to how COVID has affected her role as an investigator.
Hey, Ed. So I first of all, I think I'll start with the good, right? In confirming what Martin and the other panelists have said, we have seen a tremendous increase in asset recovery work, partially obviously because COVID has put a strain on cash and profitability for many companies, and they've increased their focus on recovering debts or judgments that had not been prioritized prior to COVID. We've also seen an increase of asset tracing work that comes from COVID PPE fraud. And so we've been asked to work on behalf of governments as well as private companies to help recover, trace and recover assets for intermediaries or sellers of PPE. On the not so great side, investigations have become a little bit more challenging on certain levels. So on-site record retrieval is difficult, delayed, and sometimes impossible for extended periods of times because of lockdowns. Source intelligence gathering is also more challenging. There's obviously no replacement for discrete face-to-face interviews conducted by experienced investigators. and there are limitations of what could sometimes be done by phone or video. Same when it comes to interviews. It's not the same to conduct an interview over phone and video when it comes to establishing rapport with the interviewee, reading their body language, or managing the dynamic of the conversation better. Surveillance is different, is challenging. It's not necessarily productive these days, given the limitations of people's movement and the fact that
or lack of movement,
or lack of movement, therefore, exactly. And business is being conducted virtually. So looking back at it, though, I think we're really blessed to have technology. Thanks to technology, we've been able to relatively seamlessly continue to do our work. I could not have imagined doing this, 20 or 30 years ago. So
yeah, I think that's right. So thank you for that. So now we're right on schedule, guys. So we're gonna move right into our substantive pieces. Each of the presenters will present a substantive piece on whether it's procedural or substantive with regard to a development in the law. I've actually chosen to lead off with a mention of the new Brazilian insolvency statute. That Brazilian insolvency statute has made its way through the Brazilian legislature. It is currently on the president's desk for signature. There is every expectation it will be signed. It is a pro-business development, and the current president of Brazil is very pro-business. So it looks like it's going to go through. What are the big highlights? Because I can only cover highlights. The first thing is, if the last time the Brazilian insolvency regime was modified was in 2006, and they did not embrace the UNCITRAL model law. This time they have adopted the UNCITRAL model law. And I know that Martin has had some role, and others, friends of ours, have had roles in supporting getting the Brazilian legal minds and legal regime to open up to the adoption of the UNCITRAL model law, and that's happened essentially wholesale, with a few changes that we'll have to see over time how those changes manifest themselves as these things work through being used by judges. Remember, this is a civil law system adopting a common law statute, or at least a statute developed primarily with the common law mindset. So we don't know, for example, how center of main interest will be interpreted by a Brazilian court. That's going to be an interesting situation when we see how Brazilian courts adopt various tests that have been developed around the world. But the basics that you should take away from this is that a foreign liquidator, whether it be a U.S. bankruptcy trustee or a liquidator appointed in the U.K. Or in the BVI, can go to Brazil and be recognized and have their estate recognized and act as if they're a Brazilian liquidator. And they will have oversight from the court in Brazil, just like they will have oversight in their home court. What's one thing that you need to understand is that the one major change is that the Brazilian discovery regime is different than the discovery regime, say, in the UK, where you have Section 236, 237, and its friends, or 2004 examinations and bankruptcy subpoenas in the United States. 2004 examinations, which we're going to talk about a little bit in the afternoon session, have literally been described as a court-sanctioned fishing expedition in the case law. That's not going to happen in Brazil. There's going to be a more restrictive discovery regime, because that's the nature of the Brazilian law now, and also the civil law in general. But the one thing that you will have access to as a liquidator in Brazil, which you don't have access to in most other places, is that Brazil has a central database with every single bank on it. And the liquidator can send out one email to all of those banks and freeze bank accounts in every bank in the country in the name of the target. As long as it's properly identified, each bank will freeze that. Now, we don't have this concept in the United States. We dream about it. We wish we had it. I don't think, Jonathan, you have this issue in the UK. So you have this ability electronically to reach out to all of the banks in the entire country and to freeze all those bank accounts. That is a huge weapon and tool in the possession of a liquidator coming from a foreign country. Although
Ed,
yes.
The problem is names. You're restricted to the name, and
Yes,
most of the debtors we deal with, this is an ineffectual remedy, practically speaking. because I find the debtors have the name, the assets in other companies' names, and therefore that nationwide freeze is ineffectual. I've actually never seen it work in a case I worked on there in terms of real effect.
I have seen it work in the sense that on the second bite, once you've sussed out how their holdings are held, when you're not dealing with debtor in the individual name, but you now have the name of the companies they're working through, whether it be a BVI or Cayman company, that can now be frozen. Those resources can be frozen. So it does work. Obviously, there are limitations. None of these tools are perfect tools, unfortunately. There are some references, and with regard to dialing back slightly the extension of bankruptcy to the debtors' controllers or administrators. So the law does dial that back somewhat. However, it does not in any way impinge upon the piercing of the corporate veil law that's in Brazil right now, which is done much more easily than it is in the United States and in the UK. So that law still survives and will be used by the liquidators in Brazil. But this idea of extension has been limited, and that is meaning that those who work in concert with or to aid and abet those who would steal assets from the estate are not going to be able to be added to the bankruptcy as debtors, co-debtors, as easily as they have in the past. So that's one of the trade-offs. And they do preserve the concept of economic group, where you're commingling assets, commingling the patrimony of the companies, and allow for freezing of other entities. So I don't want to say more than that. This is obviously we could do an entire seminar on any one of these topics. I want to turn now. That's obviously that I'm just touching on this issue. It's more to come in future sessions once we see the law actually signed by the president, and there may be some changes. I now want to turn to Warren Gluck. I did just mention the concept in Brazil of piercing the corporate veil, and Warren's going to cover the Degussa case, which is perhaps sets a new standard for piercing the corporate veil in offshore and international arbitration and perhaps liquidation. Over to you, Warren.
Oh, thanks, Ed. So this, I think Martin made the correct and exact point. So many times when we get our cases, the assets have been moved, the assets have been transferred, or were never there in the first place and are held by a separate person or entity. I have found myself up to my eyeballs in veil piercing and alter ego cases in the last year. And I wanted to sort of briefly note that there was a time when this theory, the second you said veil piercing, courts would become a bit hesitant. And what we've actually seen in the last year are cases where we're going through to judgment on some of these veil piercing factors. Easy to allege, hard to prove, but obviously you have this Crystal X case. We've got some cases on the West Coast and East Coast that are following the same pattern. And what we actually see is this sort of resurgence of the doctrine. The reason I mention up to my eyeballs is that there's always a question about choice of law, particularly when you're dealing with an international enterprise. There may be debtors incorporated in or defendants incorporated in 6 jurisdictions in your case. Now, folks who study this will tell you that the answer to choice of law questions can be unclear. Some courts, for example, in the case that I have right now before Judge Rakoff, have simply applied New York law or U.S. law to the entire shebang. This happened in the Motorola v. Uzan case. That happened in my case, Platinum Beechwood, and those are the standards that have been employed. In other cases, there have been some suggestions that you need to look to place of incorporation. You do get a kind of odd result if you do that in a multi-party case, because which defendant are you going to choose? And which defendant should work? The Second Circuit Court of Appeals in New York has partially made an important decision that applies to arbitrations, both the enforcement of arbitration awards, but probably also the determination of whether arbitration can be compelled in the first place. So now for those listening in, listen up. To the extent that you have an ongoing arbitration, an arbitration that is about to be commenced in New York, or New York is a potential enforcement jurisdiction. The Second Circuit, in an en banc decision, in which a number of commercial entities, including the Chamber of Commerce, including the Banking Association, filed amicus briefs, was asked to consider what law applies when an arbitration award from anywhere in the world is being enforced in the United States and in particular New York, but the answer shouldn't change. What they found after the court erroneously applied the district court, the lower court, erroneously applied foreign veil-piercing law, was that in all circumstances, the law of the enforcing jurisdiction must be applied. What does that mean? In this case, it's the law of the New York. And by the way, it's not going to go anywhere. There's no conflicting circuit opinions. This is the opinion, the only opinion. And so for the foreseeable future, this is now probably the law of the land as we watch other circuits weigh in. But New York is an important jurisdiction because it's a banking jurisdiction. New York is an important jurisdiction because it's a heavy jurisdiction for arbitral forum clauses. And what is now clear is that two decisions are going to be made by that New York court depending on whether they're in the position of compelling arbitration or the position of enforcing the arbitral award, again rendered anywhere. In terms of compelling arbitration, if you have a breach of contract, a breach of a commercial agreement, even a breach of a settlement with a arbitration clause in the agreement, the court is now going to apply New York law to determine whether to compel that arbitration if it's in New York. And it shouldn't matter. In fact, it's expressly deemed not to matter where the parties are from or any of the other choice of law factors or indicia that you normally see, including which entity has the greatest interest, which country has the greatest interest. All of those normal factors have gone right out the window. And what we now have is a clear and bright line rule, which is what I think the circuit was going for, to eliminate confusion.
But Warren, does it change the underlying law on what piercing the corporate veil law is in New York, or is it just saying we're going to apply it? We're going to apply New York law. We're going to remove all doubt regarding what law applies, but we're not going to touch right now anyway New York law on piercing the corporate veil.
I think that's what they said, is that they're not going to touch the law. The law remains intact. Now, what we're seeing are cases where you've got that dual test in New York, at least. There are differing tests in different states where dual tests, you're going to look for injustice to a creditor, injustice to the party, as well as a failure to observe corporate formalities, asset commingling, fraudulent transfers can be a factor. So what we have is a situation where, as compared to Brazil, for example, it may be harder to pierce the veil in New York, but compared to some jurisdictions, like I understand, for example, it can be very, very difficult in some of the English common law systems where you need to show fraud in the inception of a company in order to get around there. I think that, and really that's what Degussa was about, by the way. Because of that the court was attempting to apply, the district court was applying to a very, very high standard that didn't apply to all defendants and wouldn't have worked in New York. And now we have a bright line rule. And I don't think we've really discussed some of the impacts of this, but we should, because what's in New York? Well, the international banking system. New York also has, and I would stress the amicus curiae briefs here, which were submitted by the various chambers of commerce. New York also has statutes providing for global attachment, what others would call a worldwide freeze, in respect of an arbitration. And so suddenly you can now compel new parties to arbitration. You know what law is going to apply, and if there's a risk of dissipation during the pendency of the arbitration, such that the award could be rendered ineffectual, which is the New York standard. It's much lower than a normal seizure standard. All you need to show is there's some possibility the award could be rendered ineffectual and insolvency counts or partial solvency counts. Then you're talking about an interesting situation where not only could a court look to to the New York bail piercing law in determining how to compel the arbitration, but also in terms of how to apportion security. And if one party signed an arbitration clause in New York with a New York forum, then all do. And this opens the door for what I believe will be new tactics, both on the defense and on the plaintiff side. But also there's going to be a greater opportunity for early enforcement. Instead of perhaps waiting until you get your award, I would think that I think there's a very significant argument that under Degussa and its progeny, because it's been sent back to the district court now for the actual merits trial. I think there's a very significant argument that under Degussa and its progeny, there will be additional availability for pre-judgment security. And again, New York takes that unusual position based on Hotel 71, which we have talked about on this panel before, that anyone subject to personal jurisdiction in New York can have an order made against their property on a worldwide basis. So I would submit that what the combination of these decisions mean is that New York is sort of catching up to London and the other offshore jurisdictions in terms of the availability of worldwide injunctions in commercial cases, so arbitration cases. And there is going to be an increased ability, or at least less uncertainty concerning choice of law. And, you know, I think you can take different views about whether New York law is right, but it should be much clearer now. That's
really helpful. Thank you, Warren. And we're going to pick up the Crystal X piercing of corporate veil issue in the afternoon session. So let's move on to, thank you very much for that. Very helpful as usual. Martin's going to pick up the next topic, which is the alleged death of the Black Swan case, which allows for freestanding injunctions in what we thought was the BVI and also the rest of the Eastern Caribbean. And there's a new case out called Broad Idea. And Martin's going to first tell us what a Black Swan injunction is, because there's almost 1,000 people that have signed up for this conference, so or over 1,000. So many of them may not know what that is. And then tell us what the impact is of Broad Idea and whether it really is the death of the Black Swan.
Okay, to explain the answer to Ed's question, we have to go back in time in English law to 1979 in a House of Lords decision called the Snežana, which concluded in the early days, by the way, of the modern Mareva injunction, which is simply a tool to freeze assets prior to even the commencement of an intended action, during the action, or post-judgment, where a defendant or debtor poses an asset flight risk and where the claimant has a reasonable case, what we call good arguable case. So if you have those two elements, usually you can get a freeze order in the English system. And in 1979, when the freezing relief was still early in its early days, because I think the Mareva injunction case, Jonathan. Okay, so very quickly, in the late 70s, the House of Lords decided it's nice to have these freeze orders, but you have to have a substantive claim running in England in order to get one. You couldn't grant them as what we call standalone satellite injunctions in aid of a future judgment that might be obtained by a New York court or some other court somewhere else in the world. And the reason why satellite freezing is important is that you may have a primary case running somewhere in the world with assets located elsewhere and a defendant who poses an asset flight risk. So as soon as you say to yourself, well, we can't freeze assets in a standalone context, it blows a big hole in our armory to freeze assets, right? Because assets are everywhere, potentially not in one place. And in 2 years later, 1981, the law was changed in England, and a section 25 of the statute on civil jurisdiction allowed explicitly for this satellite freezing to happen in London. Now, so we were running in the offshore world through the 80s and the 90s and the early 2000s, thinking we don't have the power to do satellite freezing because of this old Snežana case. However, in 2009, Justice Bannister in our commercial court looked very critically at the cases and the development of this jurisdiction and concluded that no, the court does have the power to issue an injunction in the service of a prospective money judgment that may be entered in a civil case somewhere in the world against a defendant where the claim meets the standard of being good and arguable, and the defendant poses an asset flight risk. So all of a sudden, in 2009, in a case called Black Swan, it was revolutionary. Now in the BVI, where there's share capital of 400,000 companies, citist here, with assets in those companies worth trillions of dollars, held by many debtors or defendants, you could come to the BVI and freeze those shares and even freeze the assets of the BVI company, potentially under something called the Chadbra jurisdiction. If you could show that the defendant had the power to dispose of those assets indirectly, then this created a storm of activity in the BVI from 2009 forward, and case law supported it. We had the case called UCOS, which in 2013 our Court of Appeal confirmed this jurisdiction. 2016, 17, 18, we had scores of these injunctions coming out. And all of a sudden, last June, our Court of Appeal shocked all of us with a decision in broad idea saying, oh, no, we now conclude that Justice Bannister was wrong in 2009. We're going to go back to the Snežana principle in 1979, apply it, and too bad for everybody who got these injunctions. That means defendants could go backwards in time and argue for costs, cross undertakings, and damages relief, and say none of these injunctions should ever have been granted, and let's rewind the clock back to 2009 and start again. Well, I'm happy to say that it seems here in September the 30th, 3 members of the Privy Council on that fact setting, Lady Black, Lord Briggs, and Lord Kitchen concluded they issued an extraordinary order that says that the order and judgment of the Court of Appeal of the Eastern Caribbean in broad idea be stayed. So both the order and the judgment, and they reinstituted the freeze order, the Black Swan, pending the outcome of the appeal. For a whole bunch of reasons that are complicated, I think this is going to go down. This broad idea will be smashed around the head by the Privy Council, and we'll have the Black Swan back. In the meantime, there are a lot of us.
So they can say the Privy Council can say bad idea instead of broad idea with regard to the ruling of the ECCA, and set it aside.
And to further reinforce it, Ed, we've got our Bar Association wrote up a bill, and I just was in the Premier's speaking to the Premier's office this morning. It looks like by Christmas time we'll have a statute replicating what the English Parliament did in 1981 to forever put this to bed, and we'll be able to do Black Swan freezing here indefinitely.
That's fantastic. That's great. Thank you. So we'll any questions from the panel to Martin on that before I turn it over to our next speaker on that point? I think it's obviously a huge issue. It may just be a hiccup, and we'll hopefully be talking about it on the next time we get together. That broad idea has been smashed, as you say, and deemed a bad idea. We're now going to turn to Snežana Gebauer from K2 Integrity and hear from her on some investigative issues. Any of us who have done asset recovery for any length of time have had to deal with what I will call phony results and fraud with regard to the procurement of information, and to the point where sometimes the client comes to you with their investigator in tow, and an investigator you've never heard of, and they say they've got great stuff, and you're going to use it, and it turns out that it's false, and they've been hoodwinked a second time. I was involved personally, along with Chris Redman, in one of these cases in which we ultimately got these folks who promulgated this phony information thrown in jail. One of whom, a husband and wife team, one of whom passed away in jail. So it's a serious issue. So Snežana, why don't you talk to us about some of the tips that you would recommend that we as practitioners should be using, other than hiring you, of course, which is the obvious one, and not going with pretenders. Let's talk to us about how we can avoid this problem, because it is a serious problem in our world.
Thank you, Ed. As you pointed out, I think we can each probably share a story or two that we know about sellers of fraudulent or made up intelligence, phony investigators, or dodgy operatives that have complete disregard for the law, or a very unhealthy appetite for risk. I think you likely all have encountered the dilemma of what one does with intelligence or evidence that we learn after the fact was unethically or even illegally obtained. You've likely had a client that's involved in a high stake winner takes all dispute where significant premium is placed on securing actionable intelligence and acting on that as quickly as possible. These clients usually are under tremendous pressure. They're looking for a silver bullet, and they're open to exploring any option out there. So they decide they decide to hire a solo operator who represents himself or herself like a James Bond-like figure. They claim they can secure intelligence on nearly any issue and in
Can
nearly
I interrupt
any.
you for 1 second?
Of
to tell you
course.
that the people that we went after, that the client brought, there was a husband and wife team. They were former Ontario. He was a former Ontario police officer, and they'd retired to the Bahamas. And she went by the name Moneypenny, which was, of course, the secretary for Q. So you are dead on when you say James Bond.
Yeah. So anyways, but as I said, you have a situation where you have a client who's under tremendous pressure, and they decide to retain these investigators without, or individuals, I should say, without having done much due diligence or having consulted counsel. And so while there certainly have been instances where the story has a happy ending and legitimate leads are produced, they inform an effective legal strategy, there are also many stories of dreadful outcomes, such as undermined credibility in the dispute or the ongoing proceedings, indictments even, and definitely a tarnished reputation. I have one of the, as I was thinking through examples of, Ed, when you asked me to talk about this topic of phony intelligence, I remember recently we had been approached by somebody who was looking to sell to us information about the bank account information about members of the Maduro regime. So we do a lot of kleptocracy investigations and asset tracing work, and this individual had picked up on that, had approached us, and gave us what appeared to be a sample, so we can get a flavor of the type of intelligence that they had. So there's several pages of information that appear to be banking statements, balance statements. Our forensic investigators had taken a look at it and immediately found small inconsistencies in the real bank information and what was on these alleged copies. When we dug a little further, we found very, very similar documents that had been placed on a blog, on a Venezuelan blog out there, and pertained not to the alleged current members of the regime, but members of the Chavez regime from more than a decade ago. And so as we continue to probe with questions, this person became increasingly anxious and threatened to leave. And we happily agreed that that obviously he had to walk away. So with that, what are the, you asked that, what are the warning signs and when should you investigate the investigator?
Right.
So first of all, I would say always do your due diligence. Doesn't matter whether you're hiring a solo practitioner who doesn't have much of a public profile, or a renowned firm like ours or our competitors. You have to ask the right questions, and you have to feel completely comfortable with what you hear about the methods, about the approach, and about the backgrounds on the team that's going to be working on your on your assignment. What's their appetite for risk? Do they have the right track record and experience? Are you comfortable with what they're describing that they would do? Obviously, firms with larger infrastructure have more to lose, have interests and reputation to protect. But that's not to say that there are not some brilliant seasoned investigators who operate more entrepreneurially as solo practitioners out there and have the right strong moral compass. Some of the telltale signs of trouble is individuals who approach you and say they can obtain very specific, hard to obtain intelligence, usually at exorbitant prices, and they will insist on secrecy about the process. They will not disclose their methods or their sources. They will supply little or no evidence to support the findings. They usually have a minimal public profile. They would operate through an obscure entity, perhaps. They insist delivering the results in person, speaking through secure lines. They will avoid putting things in writing. As I mentioned earlier, what they describe may sound like an episode of Alias or a spy movie. They will tend to use intel agency jargon like, handlers and assets, honey traps, and in other words. They insist communicating through encrypted apps, exchanging emails through the most known and secure email providers out there. And they probably would claim that they can get you, as I said, very targeted intelligence, such as beneficial ownership of an offshore company or the balance in a particular bank account. So any of the above should really alert you that this individual is likely engaging in some type of unethical or illegal conduct. There may be hacking into someone's system or email, they're bribing somebody or infiltrating an organization through sophisticated social engineering and likely heavy pretexting. So
or they may have just come up with phony information too, meaning they haven't even got legitimate info. They just make it up and say, I've had that happen to me several times, where we've actually, because the client insisted on it, we acted on it, and you go to court and they come back, the bank comes back. Now you can check these things, but at the time, the bank says, we don't even have accounting. Our numerology, our numbering of the bank doesn't even match what you're talking about. Our bank accounts, all our numbers look like this, and yours looks completely foreign. So, in the case I was telling you about, they sent us a fax. Back then, we were dealing with faxes. To give you, I'm aging myself here. Of the bank account information, and it was clear they had just pulled it off of the internet and made a fake bank statement. But the client was enamored of it. How do you deal with that, Snežana, where you have to deal with the client is just so hungry to win that they're going to go to somebody and use this information no matter what?
Well, I mean, as I mentioned in the Venezuelan example earlier about the bank accounts, those were completely bogus statements that had been recreated by somebody to appear that they look like statements. In this instance, I think there are clearly ways to double check and verify. Corroboration is the name of the game for us, and so that's why I think getting whenever somebody is guaranteeing to provide very, very specific intelligence, as I said, it's either made up or they've obtained it through likely through illegal means and can.
Well, there's just hold on right there. There's a third way, the old-fashioned way 30 years ago that we would get information about banks is speak to someone in corporate security at a bank who's a former RCMP officer or FBI agent, who's there this is pre-formal compliance days. They used to be called corporate security departments, and they were basically a network of former policemen. And they were there to risk manage what's happening with the bank. Now, today we formally call it AML compliance, but it's the same thing. And that network of people, once you get to know it, can provide information that's real and actionable and accurate. Because if a system, it's a plumbing system in the world is interconnected called banking and payments, right? Electronic payments. If you can develop a relationship with a credible source, someone in charge of corporate security at a major bank, and you're a lawyer for that bank or you help that bank and you're working on a fraud case, they can, with their own network, get accurate information, and it's lawfully obtained because it has to do with suspicion of fraud or suspicion of criminal activity infecting the banking system. So there are ways in which this can be done legally, and then you can back channel it with using IBD discovery or other methods to have objective evidence to prove that the intelligence you're getting is accurate. So there's not, I wouldn't decry all these methods. I'm just saying that you're absolutely right. Be cautious, but there are ways to get intelligence legally.
Absolutely. I absolutely, Martin. And this is not to say that determining beneficial ownership or getting bank account information cannot be done legally or unethically. Go ahead, Ed.
Jonathan.
No, I think that's right. I mean, I think the point here is that when you've got a nefarious investigator who's telling the client one thing, effectively they're putting the client at odds with their lawyer, because the lawyer might well be saying, look, you can't trust this. And yet the client is being told by the investigator it's genuine. And obviously they're being told what they want to hear, but it does create a real tension between lawyer and client, which I think is very tricky to handle.
It does. And by the way, there are some limits. So in the United States, you have to deal with the Graham-Leach-Bliley Act to make sure that you're not stepping over that or suborning someone, because it specifically will sanction and expose a lawyer or another investigator to criminal sanctions for suborning another to violate that act. So, and I think we just have to be very careful there, because some of the older techniques, that have been used by some, I read it in a book, so I'm not going to say that I'd use it myself. But we have to be very careful about those things, because laws have popped onto the books that are meant to choke off that information, maybe with a good intent, but really in effect helping the bad guys hide the information, helping the fraudsters. This sometimes our obsession with privacy, and I think it's fair to say that we should be concerned about it, especially as we move further and further toward this sort of Big Brother world, can actually backfire and assist the bad guys to hide information. So, Snežana, if you'll wrap up, then we'll get over to Jonathan, and then we'll open it up to questions from the audience. Yeah, sure.
So this is not to say, as I said, that getting this information cannot be done legally and ethically. Quite the opposite. It can be done, and we do it. That's why we're all in business. I think I wanted to mention, you've heard from several experts, I think, during this conference on innovative use of technology to identify banking relationships, as well as artificial intelligence. I think we heard yesterday to analyze enormous amounts of financial data. They've been methodically precise and clear about how their tools work and what their limitations are. They're not speaking in obscurity, as in the examples that I outlined above. So there's no one push of a button solution to asset tracing and recovery. We all know it's a fairly complicated process that takes time, that takes a wide range of investigative methods and expertise, and it takes a really tight collaboration and partnership between experienced investigators and lawyers. There are obviously legal tools and remedies that could be leveraged throughout the process, and it's important that there's this tight collaboration. And finally, I just want to say that judgment enforcement is not a linear process. Usually, it's not find an asset, freeze it, and recover it.
It's asymmetrical for sure. It's not symmetrical.
It's exactly. So, it's in order to have this effective enforcement strategy, you really have to focus on bringing the other side to a settlement. That has to be one of the objectives from the outside, which from an investigator's perspective really means not this very targeted approach of find an asset, find a bank account, but really a broad intelligence gathering effort to not only to locate assets, but to understand the landscape in which the debtor operates, to identify potential pressure points and leverage. So adopting a broader holistic approach is better than going down a rabbit hole to find a bank account.
I agree. If we can, Warren, I just wanted to give Jonathan his full 10 minutes, but we'll come back. You want to make a quick comment, Warren?
Sure. It was on Jonathan's point just about the tension between lawyers and investigators. One role for the lawyer is to corroborate information. And so if the information is bad, we had a this year case on involving what turned out to be bad information. Now, there's often specificity in the information. We represented a U.S. bankruptcy trustee who had come into possession of information on debtors' assets located that hadn't been disclosed. What I will say is that, to my surprise, not only can you, first of all, intermediary bank discovery, as Martin suggested, is a nearly surefire way to corroborate or discorroborate the piece of intelligence. But to my surprise, courts within the offshore jurisdictions were prepared to issue what are called Norwich Pharmacal orders to determine the veracity of the intelligence, even though the intelligence wasn't admissible evidence, at least when a foreign office holder made the request. So I would say that this is something that can be checked, and the way to solve this tension is to determine truthfulness. And John, that was what your point was.
Yes, it is. And so let's turn it over to Jonathan, because he's going to cover, I think, something that naturally flows from this, which is, okay, there's arguably been a mess up in the case, and there's contempt in the air, and someone's looking to hold someone in contempt. And one of the questions that has been raised, especially in the UK system, is the use and misuse of contempt proceedings as a litigation tactic. I will tell you, I wish our judges used contempt more, because they complain and complain, but they don't do anything about it. But anyway, Jonathan, tell us, lay out the landscape for us and some of the issues.
Thank you, Ed. So I wanted to focus on sort of the use, as you say, use and misuse of contempt proceedings, and primarily, I mean, there are two issues. There's use of contempt, and also I'm going to do a little sub issue, which is just sort of contempt in the COVID era as well, which I can touch on. So the main point here is that in the UK, contempt is used a hell of a lot by claimant fraud lawyers, particularly where there may be breaches of a freezing injunction, and there is a whole procedure in place to hold a defendant or respondent to a freezing order if it's been breached, to hold them in contempt. There's a totally separate process which I will talk about. And there is a recent case where lawyers acting for the claimants, for the applicants, have been criticised for effectively weaponising that contempt process and applying improper pressure. And there has been some high-profile fallout from that. So when we talk about contempt, we're referring to the power. Here I'm talking about civil contempt, not criminal, but civil contempt. Right. So the power of the courts to apply sanctions for a party's disrespect of a court order, or where the party impedes the ability of the court to perform its function, or it defies a court authority. So it's not of itself a crime, but it is punishable by the court, punishable by the judge, and it's effectively the act of deliberately failing to obey or respect the court's authority. So it could be contempt by disobedience. For example, you disobey a breach or breach a court order or judgment, or you interfere with the court process, you're disrupting it, and that of itself can be a contempt. Now, what happens if there is a contempt? Well, a party can apply for a committal application or proceedings that are made in response to a contempt of court or a writ of sequestration. And the court needs to give permission for a party to make a committal application, which is usually a separate process. It's almost a separate set of proceedings. And what I wanted to focus on was a case this year, decision in Navigator Equities and Deripaska. And here the judge, Ms. Justice Baker, was absolutely scathing, where the applicant's lawyers, this is a Magic Circle firm, brought contempt proceedings. And it sort of provides an insight into how committal and contempt proceedings are conducted. And it sort of reinforces the real importance of impartiality of the claimant solicitors in bringing contempt proceedings. And they're not really able to use proceedings without, they need to show sufficient objectivity, and they obviously can't slant the evidence. They can't either unfairly procure evidence. They can't slant it. They've got to go in straight. And if they don't do that, they're liable for severe criticism. So in the Navigator case, that was an application for committal proceedings against Deripaska, very high-profile Russian oligarch, and that was struck out as an abusive process. The claim itself is a long-running dispute between two Russian oligarchs about the ownership of a piece of land in Moscow. And there, the claimant brought committed proceedings alleging breach of certain undertakings that were given by Deripaska. Now, what I really wanted to focus on was the criticism, because I don't think I've read a judgment in recent years which was so swingeingly scathing about the way that this claim has been, these proceedings have been brought. So I just wanted to sort of, if you don't mind, I'm just going to read a few extracts because I think it makes for a good read.
Please do.
So Mr. Justice Baker said, though I do not suppose that this is how the claimant's legal team saw what they were doing, the appearance in this case was of claimants not seeking to put Mr. Deripaska fairly on trial for contempt, but of claimants seeking to load the dice against him. And he said that the evidence that was submitted by the Magic Circle partner was seriously misleading and lacked candor. He added that the lawyer had lost or never had that degree of objectivity and detachment from her client that a fair prosecution of this contempt application with its quasi-criminal character required. That lack of objectivity infected also the presentation of the case to the court through the skeleton argument. So he went on to say that a heavy-handed, aggressively partisan fashion that was inappropriate, vexatious and unfair. And he concluded that in the working generation of 30 years or so during which I've been engaged in commercial dispute resolution in this jurisdiction, principally in this court and in London arbitrations, there has been a significant general increase in hostility and aggressiveness in the conduct of disputes. I don't think that's a controversial statement. I think we've all seen that. But I think the point is.
But can I ask you a slightly provocative question on that point?
No, go for it.
Do you think that the civility, the decline in civility, and the weaponizing of this has been somewhat influenced by the movement of American firms into the London market, or was this going to happen anyway? Because there's a little bit more bare knuckle fighting in the United States when it comes to that kind of stuff, I think. And historically, we've seen British firms, London-based firms, really take those obligations to be fair and frank. I mean, full and frank, to be very serious. And I'm not sure Americans embrace that the same way. And I'm trying to be a little bit provocative.
I know you are. No, it's a very self-reflective point you're making there, and I'm not sure I agree. I don't know if you can sort of create a narrative that means that it's sort of the US influence in the English courts. I think that the stakes have got higher. Well, I mean, the stakes have always been higher. The expense of lawyers is now, it's very expensive to do this kind of litigation. The power of the courts have extended its jurisdiction generally over the last 30 years. So you can now get, really, as you know, very powerful orders from the English courts as you can elsewhere. And I think that in those circumstances, it's much easier to sort of hold defendants to the fire in terms of, ensuring compliance. And therefore, there's been a whole industry around non-compliance in relation to freezing injunctions and court orders. And the necessary sort of consequence of that has been, well, this person's in breach of the order. What can we do? How can we make their life more difficult? And that sort of has seen the growth of the sort of contempt model.
So it's contempt within contempt. It's essentially you're committing contempt in the process of trying to show that the other side is in contempt. And, this is reminding 8 years ago when we first started talking about IBD, intermediary bank discovery, we said, everyone that was on the panel said, look, let's not abuse this tool, because if we do, we'll destroy it. And I think maybe what you're talking about is that this idea of using contempt if you abuse the tool's going to get taken away from us.
Well, exactly right.
I mean,
it's effectively, we lawyers have to walk the line here. We have to balance our duties to our clients and to the court in this kind of litigation, and and that's always going to be the test for us.
Thanks for watching. Consider subscribing to our investigative news and documents service and attending our events. For more information, visit offshorealert.com.